We're now recording, everybody.
Great. So thank you everyone for coming. And since we are spread out around the globe, good morning, good afternoon, good evening, depending on where you are. I'm Maria Volpe. I'm a professor at John Jay College and the director of the CUNY Dispute Resolution Center, one of the co-sponsors of this breakfast with the Association for Conflict Resolution of Greater New York. We have been holding these breakfasts since 9/11. They were in person until March 2020. Hard to believe that we are still virtual. Not at a choice, but we don't have a choice to continue the virtual breakfast, but it's been wonderful, as we just discussed in the pre-breakfast part, to have the ability to connect with our colleagues literally around the world. These breakfasts are recordings are posted each month at www.acr-GNY. So you can tune in again after the breakfast. These breakfasts would not be possible each month if it wasn't for our wonderful team that works on these, including Julie Denny, Chuck Newman, Nikki Borofsky, and Matthew Latimer. So I'm not going to belabor this introduction. I am going to turn it over to Julie to formally introduce our speakers this morning. Thank you so much to Kristen, Ashley, and Lisa for being here with us from Nebraska. If we were in our in-person format, we would be waiting for you to take a trip to New York. So this is the beauty of being online. Thank you so much for being with us. And I'm going to turn it over to Julie.
Good morning. It's no secret to most of us on this call that there isn't as much work available to mediators and arbitrators as there is conflict. And our panelists today have done a survey recently of ADR practitioners and lay people's understanding of the fundamental characteristics of dispute resolution and their processes. This is a topic which I suspect interests a whole lot of us professional practitioners. We have 3 professors from the University of Nebraska on with us today. Kristen Blankley is the Henry M. Grether Professor of Law at the University of Nebraska, and one of her primary interests is the intersection of dispute resolution and ethics. Lisa PytlikZillig is an associate professor at the Public Policy Center at the University of Nebraska, and she's particularly interested in public engagement around often conflictual issues, thank you, Chuck, and trust in institutions. And Ashley Votruba is an assistant professor in the law psychology program at Nebraska. And her primary research area looks at how social perception influences legal decision-making and conflict management. We're very eager to hear the results of your research and also, hopefully, some insight into how we can move forward. So welcome to all 3 of you, and take it away.
Julie, may I, Mediation Settlement Day?
Oh, thank you. Yes. Before you take it away, a reminder that Mediation Settlement Day is coming up on Thursday, October 21st. It's online from 6 to 7:30. And the reason Chuck isn't making this announcement is because he's participating in this particular event. We're giving an award to Alexandra Carter, who spoke here at the breakfast recently, Columbia Law School. And she's talking about how can we increase mentorship access and broaden the opportunities for everyone. You can register through the ACR-GNY website, which is acrgny.org. That's the 21st of October at 6 o'clock. Thank you for reminding me, Chuck. Now, Kristen and Lisa and Ashley, take it away.
Thank you. Thank you all. We're so glad to be here, and we're glad to share this research with you that was recently published in the Nebraska Law Review. I wanted to start by thanking this group in particular because, as you might recall, my first introduction to this group and this listserv was when we started to advertise and ask for survey participants, and I was recommended to this listserv that this would be a wonderful place to learn from you all and have you all answer our survey. So the first thing we wanted to do is we wanted to thank you for those of you who took our survey about 18 months ago. And we're glad to be able to come back here and report our results of what, give you a little bit more insight into what we were doing, why we were doing it, and the results from that. So I'm going to share my screen and start this PowerPoint presentation. So essentially what we are looking to do today is to, the big takeaway from the survey that we did, and I don't know if this is surprising or not surprising. We're all dispute resolution practitioners, and I think we've long feared that the public doesn't understand what it is that we do. And I think because of that, that might be part of the reason why we're not engaged as frequently on a voluntary basis as other times. Unlike the court system, which is often portrayed in the media, we know that that portrayals in the media of mediation and arbitration are few and far between and not necessarily as accurate as that we would like. And so, and part of what we did in this piece of research was to get a sense of what is it that the public knows or doesn't know about what we have determined to be essential characteristics of various ADR processes. Thank you so much for the great introduction. I wanted to add one piece, and that is to let this group know that all three of us are mediators, and we all mediate and we facilitate. And so I do a little bit also of arbitration, but the three of us come to this project not only as interested researchers, but we do have a background as practitioners as well. I also teach mediation at the law school, and Ashley and Lisa have been involved in mediation training at in various capacities across the state. So we come at this project not only from a profession, not only from a research standpoint, and not as our as professors, but also as practitioners. And so hopefully this presentation will show some of that well-roundedness that I hope that we bring to this project. Our agenda really has three pieces, and the first piece will be covered by Lisa, and that is a discussion of the prior literature. So as we went into this project, we had to determine and look at the prior, prior studies, prior literature, what would be useful as we developed our study. Ashley will take over to talk about what we did and what the results are. And then I'll have some comments at the end about what these findings mean as it relates to considerations for mediation, mediation in particular, but also other processes, particularly as it relates to things like informed consent, as it relates on the attorney side to duties of communication and client counseling. And that's our rough agenda for today. With that, we'll let Lisa take it away.
Great, thank you, Kristen. And we decided not to risk the potential technical difficulties of sharing control of the screen. So I'm just going to let Kristen know when I need to go to the next slide. So with that, Kristen, go ahead and take me to the next slide. So I am a mediator. I'm not a lawyer, but I understand from my lawyer colleagues that it is well known among the legal profession and neutrals that there's this tendency in this traditional model to kind of think it's okay if the public doesn't know everything. So according to the traditional model, the clients should be experts in their values and kind of the what or the why of the conflict. Whereas the legal professionals, they should be the ones who kind of master the processes and they know the hows and the methods. And as we note in our article, it might be entirely appropriate and accurate to do this, for example, given kind of the low success rates of pro se parties in courts and so on. But of course, if we just accepted this traditional model, then we'd not be able to do the rest of this presentation. So we're going to move on and kind of complicate that. So the next slide. Ignoring public knowledge, we're arguing, may not be optimal for a number of reasons. One reason is just that people may not be able, it's hard to prefer something you don't know about. So if the public only knows about litigation, but the legal professionals know that there's other better ways that are more efficient and so on, the public can't know that unless they know about those other processes. The other reasons, which Kristen will dive into more in detail later, is that people cannot really meaningfully consent, we would argue, without having some knowledge of the processes. As we note in our article, it's reasonable to question whether clients are giving meaningful informed consent if they agree to a process they don't understand or for which they don't know the alternatives. In fact, in my primary area is social psychology, and we are very specific in terms of not referring to, when we're doing research, consent procedures, but we refer always to informed consent procedures, which emphasizes the need for people to have that relevant information before they can give consent. So if you agree with us that yes, we should pay attention to public knowledge and so on, then we need to ask ourselves, what does it mean to know something? So at this point, this is where I'm going to problematize knowledge, because as you may know, academics are really great at turning things that don't look like problems to anybody else and turning them into problems. But actually, if you think more deeply about it, knowledge is a really complicated thing, right? It comes in different types, it's established in different ways, has different dimensions and purposes. So for example, if you think about what it means to know how to ride a bike, this is very different from knowing where a given restaurant is, which is different from knowing what a phone number is, and it takes different processes to establish. You have to practice riding a bike with your actual muscles, not just with your brain. Knowing where something's located, you're going to have some sort of spatial understanding of things relative to each other. And knowing a phone number might be just fine exercising with your brain. But even that, you're going to see different types of knowledge kind of crossing each other. So you might have noticed, if you're used to typing in your password, which seems like a really cognitive thing, but you're used to typing it in on your keyboard at your computer, and suddenly you have to access your bank from your phone because you're in line, and you have your phone and you have to type it in because your phone doesn't remember it. You don't have the muscle memory that you would have at your computer, and suddenly it's just that much harder to remember. In addition, and what I'm going to go on to next, is different types of knowledge has been categorized according to the skills and cognitive operations it takes to express or show. So that brings us to Bloom's taxonomy, which is one of the most well-known models of knowledge and used a lot in cognitive and educational psychology. There's actually a lot of different ways to slice knowledge, but we focus on this one in part because it has kind of a nice overlay with what we might want to think about as people interested in the public's knowledge when it comes to what we want them to do with that knowledge. In other words, how we might want them to be able to give consent or evaluate different processes or have input into the processes that they use. So this slide lists the levels of Blue's taxonomy. I'll go over them very briefly. At the lowest level is simply just remembering something or being able to bring it to mind. So remembering a phone number or remembering that someone at court said, for example, mediation or arbitration was offered. At a higher level, although I realize now it's in reverse order here, but anyway, at a deeper level of knowledge, which just went away. Did it go away for other people too? I wonder if we
Just
lost.
got a text message from Kristen that they lost power at her house.
Oh, well,
Let me see if I can pull this up and share my screen.
awesome, because I am not able to think and speak at the same time, which I'm sure has some cognitive bearing. I'll go ahead and keep talking though, because probably you don't need to see it exactly. At a deeper level of knowledge is understanding. So that includes things like understanding what a phone number is for, understanding what are the features of mediation would be an example of that. At the next deepest level, you would actually be able to apply that understanding. So for example, you'd be able to know that a phone number is used to call someone and then actually call someone or play the role you're supposed to play in mediation if you're applying your knowledge of mediation. At the next level, you'd be able to analyze the topic that you know about. So for example, you might understand that my 402 area code indicates a phone number in Nebraska, or you'd be able to think about the different purposes of the features of mediation, like what's the purpose of the neutral facilitator. At the next level, you'd be able to evaluate. So you'd be able to evaluate the pros and cons. So for example, back when more people had landlines, this encouraged people to realize that, oh, if I get a cell phone that's in the same area code as my landline, then other people with landlines can call me without it costing long distance. In the case, in the context that we're talking about today, if you know more about ADR processes, you might be able to evaluate the features in light of how they could meet your goals. And finally, at the highest level of knowledge, which we won't talk much about today, you could create something. So those of you who know the features very well might come across a new context in which you say, you know what, we need to recombine these features of dispute resolution to create a new process to meet this new context. I'm not sure you could ever do that with a phone number, so my analogy ends there, but moving on to the next slide. So this is kind of the overlay of Bloom's taxonomy with the work that we're doing. We've kind of chunked these into fewer categories. I'll talk a little bit about the prior literature on kind of just awareness of processes, which is very basic. Our study is kind of at the level of understanding things, like do people know what features are involved in things? And then the apply, analyze, and evaluate stuff is probably the more useful knowledge, which we don't get into, but we would encourage future research to get into if we want people to be more involved in their decisions. Okay. Next slide. There is not a lot of research on public knowledge. There tends to be, when public knowledge is mentioned in the literature, it's most often mentioned in terms of, yeah, people don't know very much, but the characteristics of that knowledge, like, well, at what level is it? Are there some things they do know and some things they don't know? There's just not very much on that, but I'll talk about what little we were able to find. So this is work by Donna Shastowski, in which she conducted a study where she surveyed litigants in 3 different state courts. And these were courts that she knew did offer litigation, mediation, and arbitration. People's awareness and memory of these offerings were kind of abysmal. So only 25% out of 100% possible recalled that their court offered mediation. Only about a quarter recalled that they offered arbitration. And when asked about both of those things, there were only 15% who said yes, both were offered. Interestingly enough, and if we get Kristen back, which I sure hope we do, related to her discussion of kind of legal counseling and so on, there was no significant difference between people who were represented and people who were not represented So if you're expecting legal parties to be letting people know these things in these offerings, they did not find a significant difference for that. The next slide. So moving up a level to understanding, there's a relevant study by Gross and Black. These researchers conducted a survey of people involved in securities arbitrations. And this was a large survey involving both more than 1,300 customers and more than 1,500 others these others were likely more experts because they were lawyers or representatives in the case. And what they found in their survey was that customers, who you might see as more close to lay people or the public, showed very little understanding of the process in which they were involved according to their answers. So for example, less than 50% of the customers compared to 94% of the other participants indicated that they knew one of the arbitrators in the case would be an industry arbitrator. So these are factual things that they asked people about. Similarly, less than half compared to 88% of the others indicated that the arbitrators were public versus industry. So that based on that factual knowledge, you can assume low knowledge. But in addition, you can look at subjective knowledge, like whether people felt like they knew things. So to that end, it's noteworthy that many customers, and significantly more customers than the expert others, also tended to use don't knows a lot when they were asked their opinions of things. So when they were asked whether the arbitration panel applied the law well, appeared competent, understood legal arguments, and so on, they had significantly more use of don't know responses, suggesting that subjectively they felt like they knew less. And another slide. Another study relating to indicators of knowledge comes from two more studies by Shatowski and colleagues. And these studies are a little more tangentially relevant, but they are relevant if you assume that people have to be able to perceive and understand something, or feel like they perceive and understand something to some extent before they can say that they prefer it. So in their 2008 study, Shatowski and Brett asked people about a variety of preferences for different process features. And then they conducted a factor analysis of these preferences. So in my field, factor analyses are used for a variety of things. And one of the things you can use them for is to see how things clump together. So if things clump together for people, then they see them as similar. And if they separate from things, then they see them as different. So you can start to get kind of an idea of what's in their head. Like, are they seeing these things as the same? Are they able to distinguish these things? So that study suggested that people seem to be attending to and forming preferences around and distinguishing on the lines of control, like who has control of the process. So this is our first clue if we're getting into, do people know anything at all? Well, they do at least seem to be paying attention to who has control over this process or outcome. Is it the disputants? Is it a third party? Is there mixed control or not? But what was interesting about that study is that even though people then expressed preferences, these did not predict the procedures that then they said that they actually used. And that could be for a variety of reasons. And in her later 2016 study, Shatowski found this similar mismatch in what people kind of preferred at a kind of feature level and at a more macro level in terms of the processes that they not just used, but actually said that they preferred. So in the first study, there could be lots of reasons why, well, I preferred this, but there's lots of reasons why I couldn't use it. But in the second study, it was actually preferences not matching with preferences. So people saying they preferred features and then saying that they preferred processes, larger processes that were inconsistent with their feature preferences. And again, Shatowski indicated a number of potential reasons for it, but this last quote on the next slide is kind of most relevant to our study, that a more compelling and troubling explanation for the apparent disconnect is that it might stem from an inaccurate understanding of which attributes actually characterize the various processes. So in summary, and then I'll turn it over to Ashley to talk about our study, there seems to be great support, well, not great support, but in the little research that's been done, there's support for what that people don't know, but we were nonetheless still interested in trying to kind of figure out in more detail what they don't know and do know.
All right, thank you, Lisa, for all of that setup. So what I'm going to do is I'm going to spend some time walking through the methods of what we did with this empirical study. And as part of that, I'm going to weave a little bit of, I guess, kind of our research story in this, and from a broader picture, what this particular group is interested in looking at. And then I'm going to provide some details on the results, and it'll be a mixture of the results that we cover in the paper. And then I'm also going to preview some of the work that we are putting together for a companion piece that's going to be coming out. So you'll get a little behind the scenes look on some of what will hopefully be published here in the next several months, near future. So to start off with, as this group was really coming together and thinking about dispute resolution and where there was a need for empirical research, we really focused on the party's perspective in things. And so that's a little bit different than what we see in some of the other empirical literature in this area. But we were interested in trying to gain a better understanding of what are predictors of people's willingness to engage in various processes. And as Lisa mentioned in the literature that she was reviewing, as we dove into this work, one of the things that I really noticed is how people were talking about and defining different options for dispute resolution processes was inconsistent. So I'd read one article that would talk about mediation, and to me, it would actually look more like an arbitration type procedure, but they were calling it mediation. And there were differences in how they had defined and sometimes not defined that for participants. And so we saw this need to really take a dive into the understanding of conflict resolution processes and what that means for different people. And so from a broader perspective, we have this overarching research goal, and the knowledge piece, as you're going to see here in just a minute, is kind of something that we had to figure out first in order to get to these other things. So the first thing that we really saw a need for was this differentiation between different processes. Can we really understand what it is that key features that distinguish between these? And then can we create some sort of maybe profile or sort of general understanding of what these processes look like? We were also interested in then taking that information and comparing experts and community members to each other to get a sense of what their perceptions are. And then ultimately, and this is where we're going with the research we're currently doing and what we hope to do in the future, is can we use this to better understand people's conflict resolution motivations and preferences? Now, to do all of this, and I really have to thank Lisa and Kristen because our conversations really cemented this early on in the process, but we needed to understand, what is it that people actually know about these dispute resolution processes before we can get to these next steps. So the first thing I'm going to spend a little bit of time walking through is this initial step that we took, and this is before our survey, but I think it's important to lay this out in order to have an understanding of where we were coming from. And that's just to identify and try to understand what are the differences between key process features. And a little background about myself, I'm a social psychologist primarily by training. I have an interest in law. So I went to law school. I learned how to mediate at a mediation clinic in a law school, which was an absolutely wonderful experience. Beyond that, though, I didn't have a lot of exposure to kind of the technical pieces of different types of dispute resolution until I started diving into this area of literature. And it was sort of one of those as I was learning and trying to figure this out, it became really clear that this wasn't as straightforward as it seemed at first glance. So the first thing that we felt we really needed to do if we were going to look at how the public views dispute resolution processes was to take apart the processes as we're introducing them to community members. We can't just say, mediation, arbitration. We had to really understand what are the hallmark or the key features of those different processes and how do we distinguish between them. So to do that, we wanted to develop this comprehensive list of ways in which different processes could vary. And so to do that, we went in and took a deep dive into the literature. So we looked at academic resources, including textbooks, treatises. We also looked at more public-focused resources. So took practitioner-oriented descriptions as well as general public-oriented descriptions from a variety of different websites. And we wanted to understand how are these things described. And to do that, we pulled all of these resources together And we were really looking for something that was comprehensive in the sense that we pulled from a lot of different locations and different types of sources, but we recognized we weren't gathering absolutely everything. So it's not exhaustive in that sense. And from there, we've looked to go through and do a thematic analysis. And so we took a description like this one, and this is an example of mediation. And as part of that, we started to just pull out, what are the key ideas, the key features of these different processes. And then with those, definitions of each of those different aspects. And so you can see I've done some of those there from this particular text. We did this across the board from all sorts of different resources that we had and generated a list of different types of process features. And so what I'm showing here is a lot, but this is essentially 18 different process features that we were able to come up with. What I don't have pictured here are an additional 5 that are really focused on the features of a neutral third party when we have one. So that's not always the case, but I left that off for the sake of space and time today. And so you can see we have these 18 different aspects. And as people who mediate, a lot of these are features that we see as hallmarks of mediation or things that we really value. So the fact that these processes are self-determined, that they can be collaborative at times, and so on. And so we had this list of key process features. And then the next step was to take this to the public and to survey people's perceptions of dispute resolution processes along these key features. So the next data that I'm going to be talking about is from our empirical study. This is work that is survey-based, and so keep in mind with that, we do have certain limitations. All of this is self-reported, so we're getting self-reported participants, community members' perceptions of their knowledge, and so on. So we're not giving them actual, tests like I would a student of people's knowledge. So for our study, we collected 2 different samples. We had a community sample and an expert sample. The community sample consisted of a little over 600 community members taken from Mechanical Turk. If you're not familiar with Mechanical Turk, it is a service offered through Amazon where people can sign up as quote unquote workers to engage in market research and academic research for money. There are sometimes issues with Mechanical Turk, and so, as a social scientist, we do a lot at the front end and then the back end to make sure that we have really good quality data. So we do screenings of our participants, we ask attention check questions, and then we can also go back and look at things like how long it takes them to go through the survey to then make sure that the data that we curate is a really nice section of the data. And so these 632 people fit with that. Demographically, they fit with what we often see in terms of pulling from this sample. So a mean age of approximately 40, slightly more men than women, and 65% identified as white European American. For our expert sample, we pulled our experts from various ADR listservs, including this one. So we had 254 people respond. You'll see the mean age here is quite a bit higher than our community sample, so almost 56 years old, 42% men, 44% women, and then 53% identified as white European American. So I'm going to walk us through the general survey procedure so you can get a sense of what this looked like. Again, if you took the survey, this should be pretty familiar to you, so hopefully it'll jog your memory. So initially, with the community members, we had some concerns that there might be people that didn't have even enough knowledge to answer our question. And from a data analysis perspective, that can make things really messy and difficult to sort through. So we wanted to start off with a question about how familiar are you with these different processes? And what we did with this question was we were able to use it to kind of filter people out. So if they suggested that they had absolutely no familiarity with a particular process, they did not receive questions about that process. So for the community members, this question occurred early on in the study. And then next we asked them to assess 5 different dispute resolution processes for each of the dispute resolution features that I had listed on a previous slide. And I will show you an example of what that looks like in just a minute. But first, a quick word on the 5 dispute resolution processes that we chose. So our goal was to really have a breadth of different processes that are out there that exist. This is not comprehensive. There's a lot that we did not include, but we wanted to make sure that we touched on a couple of key pieces. So we chose litigation, arbitration, mediation, and negotiation. And then you'll see that we've also broken this up into 2 categories of mediation, evaluative and facilitative. The reason for that is that we had gotten feedback early on from experts that in order for experts to respond to this and to answer in a meaningful way that would give us the information we were looking for, that we would have to specify and distinguish between those 2 types of mediation because of the important ways that they're different from one another. So we decided to separate those and include 2 different categories. And then the last part of the survey included reporting of participant information. So oftentimes we call this the demographic section. So the demographics that I presented earlier were asked at the end, along with a few questions where we asked people to report more information about their knowledge of the dispute resolution processes, as well as their experience with those processes. So here is an example, and I hope this is large enough on your screens, but this gives you a sense of what the study looked like from the participants' perspective. So this is the familiarity question, and we asked them, before we examine your perceptions of these different dispute resolution processes, we want to understand how familiar you are. And then we listed out those 5 processes, and they were able to select between the 5 different, from I have never heard of this term until now, until I've heard of it and I know quite a bit about it. Then for the process ratings, this is what it looked like for participants. So a couple of things here. In our earlier slide, I had defined each of the features. So we had talked about, self-determination. For the participants, what we did was we didn't provide terminology per se. We didn't want this to be a vocabulary test, but instead offered up definitions of each of those features. So this is the question for voluntariness. So in this dispute resolution mechanism, how often do the people involved decide for themselves whether to participate? And the participants could take that blue slider and move it along the sliding board from never to always. And then we had each of the 5 ratings set up in order like this on purpose, with the hopes that people could sort of make explicit comparisons. We wanted them to have that information as they were reading each of the 5 processes. And then importantly, we always included a don't know category. To the extent we're looking for meaningful information, we wanted people to have the option to just not provide anything if they just didn't know. All right, so I'm going to walk through the results, starting with the community sample and really just focusing on these perceptions of knowledge, which is what we have been building up to today. So I'm going to take a minute and just walk us through this graph. Hopefully everybody can see the colors okay on your computer. But essentially what we have are bars for each of the different dispute resolution processes. Starting with the pink bar, which is litigation, arbitration is purple, evaluative mediation comes 3rd, which is teal, red for facilitated mediation, and then darker purple, dark blue for negotiation. And so I'm showing a frequency distribution here. So we can see how many people responded to never heard of the term, all the way to a great deal of knowledge of those particular terms. And so what I want to draw your attention to here in general is that when we look at the negotiation bar, which is this darker purple sort of bluish bar, we can see that people have quite a bit of familiarity with this. And overall, this was ranked as significantly more familiar than the others. They had the least familiarity with our 2 types of mediation. And so almost 75% of people, and I will show that here, said that they lacked familiarity with the 2 types of mediation. And you can see that in comparison to our others, litigation, arbitration, and negotiation. And so this table is representing, people who were in that first category who said that they didn't have any familiarity with, compared to the people who at least had some familiarity with the process. And so I don't know about my colleagues, but when I saw this, I found this a little bit shocking, right? Being somebody who works in this world and has research in this area and some experience in this area, it seemed surprising to me that so few people were familiar with mediation. So the next question that we're going to focus on is that of reported knowledge. So a little bit different than familiarity in the sense that knowledge is requiring probably a higher level of understanding. Again, though, what we're seeing overall is that people are reporting very low levels of knowledge. So they're selecting not knowledgeable a vast majority of the time, especially for our two types of mediation. Where we're seeing the most reported knowledge is for negotiation, maybe unsurprisingly. And then this third graph, which is set up the same way, is showing the extent to which people have experience with these different processes. And so if we take a look at the very experienced side, we can see the most is being reported for negotiation, and that persists in general across these middle categories as well. So overall, people reported the most experience with negotiation. Next was litigation. Third was arbitration. And then the least experience with our two types of mediation. So we've talked early on about these community perceptions, community knowledge, and one of the things that we want to understand are what are the implications of that for people's understanding of the processes. So we didn't just want to report, this sort of lack of knowledge or lack of understanding that we have suspected. We also wanted to think about what are the implications of that. And so to do this, what we did was we took a look at our participants who reported at least some familiarity with the different processes, had them rate those processes along each of the features, like I showed earlier, and then from there had them compared to the expert perceptions. And so I want to run through just a couple of the results on that. And for the sake of this group and what we were interested in as part of this project, I'm going to focus on the voluntariness, so the extent to which people perceived a particular process as being one in which they could voluntarily engage or decide to engage in. Self-determination, so the extent to which the parties themselves are the ones deciding how to resolve a particular dispute. And then third, the extent to which it is seen as being collaborative. So to what extent are people working together to reach a decision at the end, a resolution? All right, so starting off with self-determination, we did some statistics where we were able to explicitly compare, on average, what are the perceptions of community members and experts. And we were specifically looking to see cases in which community members and experts would differ from one another. And so if you take a look at the graph, we have community members in teal and experts in blue. And the bars that are noted with a star are those in which we see significant differences between community members and experts. And so as it relates to how often something is self-determined, what we're seeing is that community members and experts generally see litigation and arbitration very similarly. So those ratings of self-determination are below the mean point on our scale, or the median point, middle point. So they're fairly low. But when it comes to our two forms of mediation and negotiation, we're seeing that experts see those as being more self-determined compared to our community sample participants. So to take a little bit of a deeper dive into this, I also want to present some of the newer data, a new way of looking at this, where we have taken a look at the distributions across the different characteristics for each of the different processes. And so what you're seeing is a frequency distribution in dark gray and light gray. And so that's how many participants are hitting at the different points of the scale. And then embedded within those is a histogram. And so the middle line of the histogram is the mean point. So you can see where those mean points align or are different. And then a little bit more distribution information there. And so what I want to draw your attention to, and what we saw reflected in that last graph, was that if we look at something like negotiation, we're seeing quite a bit of similarity in the distributions between our experts and our community members. But when we take a look at our mediations, for example, we can see the experts are showing more agreement, so their distributions are a bit more scrunched at that high end, but our community members have wider distributions, and they seem to be focused at that midpoint on the scale. And so that is indicating sort of lack of agreement between our community members on what these processes look like, which is likely an outcome of this misunderstanding or inability to really get at what it is about these processes that suggest self-determination. We also took a look at voluntariness. And so same sort of basic analysis comparing community members and experts. And again, what we're seeing are some significant difference between the two groups. So generally, experts are seeing more voluntariness, especially as it relates to our two forms of mediation and negotiation. And for this, there was no difference between the two groups as it related to arbitration. And once again, I also have these plots showing the distribution here between our community members and our expert members. And again, you can see these distributions for mediation are showing more agreement with the experts towards the high end of voluntariness. And our community members are hanging out here in the middle point of the scale, less agreement there. And then finally, the collaborative nature of the process. So we wanted to compare community members' perceptions and expert members' perceptions of how collaborative are these particular processes. And we have some interesting results once again. So no differences in litigation. Generally, that's seen as being fairly low on collaborativeness for both of our expert members and our community sample. For arbitration, there was an interesting finding here that community members are seeing that as being more collaborative compared to our experts. So our experts rated that very similarly to litigation, but community members put that more towards that middle point of the scale. And then the flip occurred for facilitative mediation. So our experts see that as incredibly high on collaborativeness, over an 8 on our 10-point scale. Our community members saw that as lower. And then there was a significant difference in negotiation with community members seeing that is slightly more collaborative than our experts. Excuse me. All right, and then we have the distributions again here. And so you can see from litigation, lots of agreement that these are low on collaborativeness as pointed out before. And again, with our mediations, we're seeing that our community members having kind of this broader band of distribution, suggesting that there's just less agreement there in terms of how they're perceiving these particular features. All right, so I know that was a lot, so I just want to summarize and put everything together, and then I'm going to turn it over to Kristen. So in general, when we look at community members' familiarity with and knowledge of different dispute resolution processes, people are reporting the most knowledge and familiarity with negotiation, and then litigation and arbitration, and not much with evaluative and facilitative mediation. And in part, we don't know why that's going on. We haven't tested that, but we do have some ideas that this is probably due to media portrayal and the extent to which things like litigation and arbitration are being talked about in everyday culture. They're just more out there. They're more pervasive in our everyday dialogue, and mediation less so. And we do wonder and would like to test, although I don't know if this is going to be something to do in the near future, but whether these additional words, that distinction between evaluative mediation and facilitative mediation was pretty technical, and if it really threw off our participants, especially in our community sample. So testing that with maybe just the term mediation and seeing if we can get sort of higher reported knowledge in those cases. And then when it comes to our community members' experiences, we saw that a large percentage, I believe was almost half, have experience with negotiation. And again, this makes a lot of sense. It's something that we do frequently in life. If you've ever bought a car or any other major purchase like a home, there's often negotiation process that goes with that. But when it came to all of our other processes, reported experiences were pretty low, as you would expect. And so it makes some sense that there wouldn't be direct knowledge of these processes as a consequence of that. And then finally, as it relates to comparing our experts and community members, there were some cases where we saw agreement in those perceptions, especially as it related to negotiation and litigation. But there were differences, especially for facilitated mediation, evaluated mediation, and arbitration. And so we're not always on the same page when it comes to these perceptions. And then also, just in general, experts tended to see things more similarly to one another. There were tighter distributions compared to community members. So there's just a lot less agreement in community members about what these different process features look like. All right, and I see the chat has been very active. So thank you so much, Kristen and Lisa, for helping out with that while I was talking. And I'm going to turn it over to Kristen.
Okay, thank you. And one of the things that we didn't talk specifically about why we did this project, and maybe some of the why can be helpful, especially as these questions come in. And we were originally thinking, and we have a kind of a follow-up project that is in the works that intends on asking individuals what they want out of conflict resolution. And as social scientists, which I am not, but my colleagues are, and they understand that in the world of social science, that there are certain measures and certain types of questions that have been tested by other scholars and other researchers. But in the world of ADR, there has never been a study that asks professionals or others, what are those features? And so when Ashley was talking about starting with the literature and looking at those different things from the literature, how we as ADR professionals and lawyers and other types of professionals understand what ADR is has largely been from textual types of has been from textual types of research, whether that be law review articles or treatises or other things. And so this was a really interesting first step that hadn't been done before. And originally we were only going, at one point we had considered only testing experts. That was a conversation that we had, whether or not we would only text experts to see whether or not those who are providing these services agreed as to what those services are about. And that is where we got, where we ended up with a lot of conversations, difficult conversations about mediation and what is mediation. There was a comment in the chat about, well, it's unfortunate you didn't include facilitative we didn't include transformative mediation. And we did have questions, right? When we talked about mediation, especially with experts, we were concerned that if we surveyed experts and said, how voluntary is mediation, without a qualifier, that we would get different answers from different neutrals depending on how they approached mediation. And that a transformative or narrative or understanding-based mediator might have a very different perception of what voluntariness, self-determination, all of those other things might be compared to someone who practices more evaluative mediation where the parties aren't in the same room. And so that's a little bit about how we got to where we got. And then we had the opportunity while simultaneously test both experts as well as laypersons. And when that opportunity arose, we jumped on it and we said, absolutely. This research was funded by our university. We received some seed funding for that. We are hoping that we can take this initial research. We would love to be able to find federal funding for this at some point in time as the project gets bigger, but the initial funding for this project has been internal funding. And that's an excellent question. We appreciate that. And what we found, like I said, what we started by doing when we received this data, one of the things that jumped out at us was that lack of familiarity as it related to mediation. And if we assume that part of the lack of familiarity as it relates to mediation is really due to a lack of familiarity and not due to terminology or that sort of thing, it brought up the question about ethical implications, and that's where we want to start. So go to the next slide. So the question here is, how do these types of findings relate to informed consent and self-determination? And of course, informed consent, especially as it relates to mediation, is one of our primary concerns for mediators. In our model standards of conduct for mediators, it is kind of self-determination is standard 1A talks about it specifically. I highlighted a handful of considerations regarding self-determination, things involving free and informed choices. At any stage of the mediation, including choosing the mediator, process design, participation, or withdrawal. And then we, of course, have over time have finessed self-determination in some instances when parties are mandated to mediate. And so that's an entirely different discussion. But one of the questions that we had asked about ethical implications is how informed and how free are these choices if the parties do not understand the process? And so we can go to the next slide there. Professor Nolan Haley, who this group is probably very well familiar with, she's done a lot of research, excellent research on the area of informed consent. And informed consent informed consent has these elements of both disclosure and consent. And one of the things that I like about the lawyer model rules of professional conduct is when they describe informed consent or define informed consent in Rule 1.0, the definition section, they know that set of rules notes that informed consent is an agreement by a person with a lawyer, an agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material and risks and reasonably available alternatives to the proposed course of action. In other words, this is similar to what Professor Nolan Haley was talking about regarding information, disclosure, and consent. And in the model rules of professional conduct for lawyers, it's really explicit that lawyers are supposed to provide alternatives. So not just, do you want to go to court? Here are the things about court, but this rule suggests discussing what other alternatives are. And there's been so much discussion over the past 3 to 5 decades over whether or not the lawyer's role includes suggesting counseling, etc., on other types of dispute resolution. And so if we go to the next slide. And so informed consent is, of course, a pillar for all of our ADR processes. We oftentimes talk about informed consent as it relates to mediation, but it's not only mediation. And the issues of informed consent, they happen at different points in time in different places. Arbitration, of course, is a system that is built on consent, perhaps not informed consent, but it's built on a system of consent, but consent related to contract, and usually pre-dispute. So we look at that consent at the time that a contract has been put into place, as opposed to at the time that parties decide to, at the time that the dispute arises in most instances. And then informed consent, as I mentioned, is a pillar in mediation. For those of you who are engaged in processes that we did not cover in this particular survey, notably collaborative law, ombuds processes, other types of consensual processes, informed consent really is a pillar in many of those different types of things. And so if we move along, and for mediators in particular, mediators might obtain informed consent in places such as case intake. And for those of you who are mediators on this call, you might have case intake that is done either through staff, case intake that is done through you as mediators. This might be a nice time to describe what the mediation process is, to ensure that the parties are interested in mediation. If this is a case that is mandated that it be mediated, whether through a court referral or otherwise, that there could be that educational component with whoever it is that does the case intake. Even if we're talking about a day of court small claims type of mediation, we can, as we start those mediation processes, assess whether or not the parties are consenting and providing informed consent. Pre-mediation communications is another place where informed consent could be, where we could look at or emphasize trying to have informed consent through those communications. Let's move on. I think that the next piece is our mediator opening remarks, whether you call that an introduction or an opening statement. This is that classic place of where we expect mediators to obtain informed consent. And one piece I want to note here is that it's possible that this is kind of late in the game because the parties are already there and we've already started working with them. It's possible that we might want to move up the question of informed consent to intake or sometime prior to getting the parties to the table. I have some concerns about the psychological impact of something like sunk costs, where if we've gone through a series of intake and pre-mediation communications, by the time we're at the mediator opening statement, which is the time where we normally think of as mediators explaining the process, explaining those choices to the parties, confirming party consent, I have some question in my mind about whether or not that's too late. It's certainly a time where we need to emphasize informed consent, particularly informed consent as it relates to the process itself, as well as, of course, and this is, of course, a wonderful time to, in the mediator's opening remarks, to remind the parties regarding informed consent as to the outcome. But of course, our informed consent that we're concerned about as mediators is both the process and the outcome. So the fourth place, anytime a question arises, we should be willing to address that question of informed consent as it goes along. And then the next piece, we might we might want to also raise informed consent regarding settlement negotiations. That would be a question of informed consent regarding settlement, whether or not the parties settle, as opposed to a question of informed consent relating to the process. Again, these are we're trying in this piece to hit in the ideas of informed consent, both as it relates to outcome and as it relates to process. We might need to make additional, thanks for the great question on, is informed consent recognized by the signature of the participants or verbal acknowledgement? And, and I know that mediators have different practices, and an informed consent is a difficult topic, both academically as well as in practice, because because it can be revoked. And so how do we show that there was informed consent? I think part of us as mediators, we really want the parties to have informed consent. And that is a difficult question, of course, to determine whether or not, sometimes I use the term, right, in the heart of hearts of our participants, have they actually consented freely and knowingly? And is the signature on a paper, right? That's a great question for a legal proceeding if parties are trying to undo a settlement that was reached in mediation. And I do think that it gets at part of whether or not there really is informed consent. And I think part of what we're trying to balance is informed consent as a legal concept, informed consent as an actual thing that parties agree to. And I'm not certain that there is agreement in the literature regarding, I'm not certain that there's agreement in the literature regarding what informed consent means and how it should go along. As I mentioned, Professor Nolan Haley at Fordham, she spent a career working on issues of informed consent, and she's not the only one, but she's probably the leading expert on informed consent, especially as it relates to mediation. Informed consent may be a particularly difficult concept or maybe particularly difficult to judge as it relates to pro se parties. And so when parties come to mediation with their attorneys, we hope that those attorneys have done their side of the legwork regarding describing the process and getting parties ready for that. However, there are many instances, particularly in community mediation, for many of us in family mediation. There's a very interesting phenomena in the state of Nebraska. For instance, we talk about cultural differences across the country. I can give you a very interesting cultural difference across the state of Nebraska. If you are in the eastern part of the state and you're a family law mediator, if you're in Lincoln or Omaha, as well as the rural communities in the eastern part of the state, when I mediate family cases in the eastern part of the state, I never have attorneys. I always have people show up on their own, whether they are represented or not. When I am mediating virtually for family parties on the greater Nebraska, so Western mediation and other places, it's really interesting that the parties will come with counsel. And so what informed consent means can be different depending on all of those considerations. So we might have parties who are at the mediation, who are represented but not at the mediation, and we might have parties who are truly pro se. But whenever we have parties who are not there with counsel or other support person, we want to think about how it is that we are describing informed consent. And this was something that I've seen in the chat as well about questions about our surveys. Are we using terms that are ordinarily understood? Are we using legal jargon? I rarely use the words informed consent. I sometimes use the word voluntariness, but we want to think about as we go through the mediation with parties who do not have lawyers there, so that they understand what it is that we do. One thing that I like to say to parties is that I'm here as long as it's helpful. And I like to say things like, I cannot make these choices for you, and it's okay if you do not come to an agreement. And sometimes I also tell parties things like, that I'm willing to take cues from them regarding how the process goes. And so we want to be able to have ways to express what it is that we want our parties to know and understand. The next piece, we can move this up one. Providing details goes along with what I had just said in terms of how that we can give the parties options, especially when we talk about if the parties are going to be together or separate. We can give them some ideas about why that might be helpful or useful so that they can make choices regarding regarding how the mediation will be. Can keep going. We can provide examples. I think we can put all of these on this slide. Encourage questions and well as answer, kind of checking back in, closing that feedback loop if the parties have questions. Let's move on. Oh wait, I said that we have all sorts of different things. There is a question: can neutrals rely on lawyers to explain mediation? And that is if our if our parties are represented either at the table, or if the parties are represented but the lawyer does not show up to the mediation. I think we have this idea as professionals that if a party is represented, that we can, I think what the profession tells us is that we can rely on the lawyers to explain mediation prior to the parties coming. And that asks this question about where do we shift, where do we put the burden of informed consent if in fact the lay population, if going back to our survey, if the lay population doesn't actually know what mediation is, where is the burden? Is the burden on the neutrals, or is the burden on the lawyers, or is the burden on both of them? The next question I ask is even more, is another place where we might think about where is this burden, and that is on ADR providers. Should ADR providers do more? And part of what we can do there, we can ask questions about whether or not should our ADR providers, whether these be community mediation centers, whether these be major provider organizations of arbitral providers and mediation providers, whether this be those SROs like FINRA, is there a burden on those organizations, or should there be some responsibility on those organizations to be doing public-facing types of information, public-facing types of education? I've had, I'm on a board of a community mediation center, and we've talked, as many of you probably have, about do we do workshops? Do we do a commercial? Do we use public access airtime? Do we put up billboards? How is it that we help people understand what it is? And I appreciate Robin's comment in the chat about time constraints. And so informed consent can be particularly difficult if we are mediating in an hour or less. Many of us are involved in programs involving court-connected programs like small claims court. Now we're seeing this in eviction and foreclosure proceedings, where we have in the small claims court where Ashley and Lisa and I all mediate, we have 40 minutes, 45 minutes. We're lucky if we get an hour. And so what do we do with the time that we have? And so these are a lot of questions that we're asking based on the possibility that there isn't that baseline knowledge. And if there's not that baseline knowledge, should we treat mediation in particularly differently than we treat the court system? So if we move along. Ethical implications for lawyers. Oh, Jess, thanks for the question about how this research is used and shared. And so this is a published law review article. That law review article, if you want to read and get more information, that was in the link. Thank you so much to our conveners for putting that, for linking to our article. Please feel free to go to that article and read it. We have been distributing that article to our listservs of professionals, as well as, and now we're doing these types of things. We're kind of, we're accepting invitations to talk about this research, and we're very happy to do that. Very briefly, ethical implications for lawyers, if we move to the next slide. So possible ethical rules that implicate lawyers here is going to be, and if you want to just put those up. If we look at the ethical rules for lawyers, there's really two places where informed consent really comes in. And I've already talked about the definition of that the definition in Rule 1.0 is useful to figure out what informed consent is. There are really two places as it relates to this conversation where legal ethics and informed consent as it relates to these types of decisions. And so the first is the decision-making rule, Rule 1.2, and the scope of authority of attorneys versus the scope of authority of clients. And Lisa's already talked about kind of that traditional model where clients decide ends and lawyers decide means, but of course that is changing. And there are movements for more clients that are counseling, and how Rule 1.2 kind of intersects with attorney-client counseling. And then the communication rule, informed consent cannot work without communication. And so Rule 1.4, our lawyer duty of communication, also is implicated. So if we move forward, there is this debate. We've seen this, as I mentioned earlier, in the literature about whether lawyers should be ethically required to counsel clients about ADR options. This is a debate that has happened at various places across the globe. There are some jurisdictions in Canada that have placed on family lawyers the obligation to talk about processes such as collaborative law. This is another area where this particular debate has been brewing. At this point, very few of our legal ethics guidelines have required that counseling regarding ADR options, although it's certainly something that can be done. Particularly, we see in Rule 2.1, the lawyer's duty as counselor. This might be a place where ADR options and our lawyer duty as counselor really intersect, and so that's a piece to be considering. If we move along. So we have a little over 10 minutes that we could certainly answer questions. Either we've been taking questions from the chat, but there might be questions otherwise.
I have to say, you guys are phenomenal at responding to questions on the fly. How about, let's see. Everybody's thanking you. They're all loving this. They all want your slides. We've already sent one link out and we will send another one out afterwards. I'm not seeing any questions that you all have not answered.
I have one, but I wanted to wait for the rest of the audience
to
pose any questions. Okay, if there's a gap at the moment. Thank you so much for this. It's amazing. You know, I have a funny reaction to this because I think everyone who mediates comes away from, if not sooner, no later than the end of the opening statement where they say, oh, these people don't know what mediation is. Well, duh. On the other hand, it is incredibly important that we now have the data on this. You have turned what everyone takes in our internal kishkas as the way the world works and have given us some hard data about it. It's phenomenal. It's very, very helpful. But I wonder if, and it's really helpful to point out the ethical obligations of practitioners to be teaching the people who will be in a conflict resolution process with them. But I wonder if we could take this one step further. And I'm thinking that I'm taking you beyond the expertise that you've built and offering this as a question to the whole group, which is, if we know all this to be true, we knew it in our guts, now we have facts and figures and charts and graphs. What is the obligation for public opinion molders to better inform the public about the different options in conflict resolution and the differences among those options? So clergymen, school teachers, bartenders, hairdressers and barbers, and certainly social media influencers. What we've seen over the years is the stuff about conflict resolution that grabs public attention is the dramatic stuff.
Yeah.
It's warfare. It's someone at the end of the Perry Mason episode every week, someone in the back of the audience stands up and admits to the murder. The developments, the breakthroughs in a mediation session are often much more subtle than that, and they're much more internal. When someone realizes, oh, I guess it really doesn't matter to Billy whether the parents switch the visitation at dinner or at bedtime. I never thought about that before, but that really creates a change in the person when they have that realization. No audience wants to see that, but no, that's not going to draw an audience. So what do we do to help people understand what the benefits of different sorts of ADR processes are, and in particular, the benefits of mediation, so that the word gets out from trusted sources to the general public? Subsidiary question to that is, what do practitioners like us do in order to get the word out to those influencers?
Thanks, Chuck. I might ask if Lisa's done a lot of work about trust in public institution, and I'm going to put her on the spot to see whether or not some of her research in regarding trust and how we trust public institutions and others might help inform some of your question.
Okay.
Yeah, good.
Well, thanks, Kristen. I think I'll just tell you some of the things that were kind of half going through mind, because I don't really have a good answer other than what free flowing went through my mind. One is the idea that it's very true that who it comes from matters. So attending to influencers or people that are already trusted and people who already have people's attention is so much more effective than trying to do it yourself. Like taking it upon yourself as like somebody like, who are you? Is not going to be effective. The other thing I'm increasingly interested in, kind of related to that, is a lot of times when I'm studying trust in institutions or talking with other people about it, they focus on an institution, like, do they trust this institution? What we're talking about here is the fact that there are many institutions involved in any decision. So in a mediation, there's a judge, well, in small claims, which I have most experience with, there's a judge, there's a mediator, there's the other party, and we need to pay attention to trust in these multiple parties. But the other thing I was thinking about is, can we make that interesting? I mean, some of these subtle aha experiences. I mean, somebody made kindness interesting with Ted Lasso. Can we get them to write something on mediation that, makes this stuff interesting to people? Because, I don't think it is just interesting to us. I think it's just like we see it and we recognize the rareness and we recognize. So maybe we shouldn't give up on that as well. Okay, that's all I got.
Yeah, there was a television show back a while ago called The Mediator. And I think they missed an opportunity because there wasn't anything subtle about it. And it was very directive. And, our problem solver saw the wisdom of her own words and shared them freely with us. But I keep thinking there's a way in public media, both television and social media, to share some of the more moving, powerful examples of how this awareness can be increased.
Well, Lisa, I'm so glad you brought up Ted Lasso. Thank you. I was 21 years in the field of market research, and I'm so impressed by the work that you've done. I mean, I don't even know what to say about it, except that I think this is really trailblazing work. Thank you.
Alan Marks has his hand up.
Yeah, I'm wondering, in the climate that we're living in the cult and culture of personality, where we used to think of ourselves as a country of laws and institutions, and so much of that has been undermined. in talking about institutions and talking about the law, how much can really be done in a culture where it's no longer the abstractions of institutions and law, but the people who are put in place to enforce and uphold those laws and institutions that has been undermined?
You know, that's such a great question, and I think that the answer to that question depends on the situation and whether we're mediating, you know, community disputes, if we're getting involved in public policy discussions and facilitations. But one of the things that I like to teach my law students about mediation is, and I just like to shift the paradigm entirely with my law students, and I try to let them understand that, or I say these things that I think are really revolutionary, things like the truth doesn't really matter, at least not in the same way in mediation. The determination of historical fact doesn't matter, right? We can talk about historical fact. We can't resolve it in mediation. We can talk about the application of law, but we don't resolve it in mediation. And what we're really trying to do is we're trying to find a way to make people comfortable with making decisions on how they will move forward. And because of that, when I frame it this way, the pieces involving cultural competency, the pieces involving diversity, equity, and inclusion, pieces involving all of those things just fall into play where it doesn't matter. I give an example of a conversation, or there was a dinner event. Some of you might be, the exact example escapes me at the moment, but there was a collegiate dinner event where a college president wanted to get the impressions of minority students on campus and held these dinners, but held them in a way that made the minority students feel very uncomfortable by resorting to stereotypes, and in how the meal was served and what was served and what the decorations were and all those sorts of things. And it gave us this opportunity to talk about, it doesn't matter objectively how many people thought that dinner was right or wrong, whether the choice of menu was right or wrong, whether the choice of decorations was right or wrong. What mattered was that those dinners were a failure, in that the goal of what was supposed to be done, understanding the experiences of various students on campus, was not accomplished. And so I think by shifting the paradigm, and as we talk about, you know, figuring out what the goal of mediation is, that we can move forward on that. So that's kind of one of my initial reactions. Thanks, Alan. And I know we're getting close on time. I'll turn it back over to the conveners.
Well, let me just ask this, if I may, and Julie's going to have to drop off in a couple of seconds, but this is Chuck. Thank you for all of that. I'm wondering if the presenters can stay a little after 10. We will wrap up at 10, which is 2 minutes from now. But if possible, if some or all of the speakers could stay, we can spend a few more minutes, you know, taking more questions and having more conversation. Thanks. I don't see any other little yellow raised hands. Did anyone else just want to open his mic and say something? Oh, there's Brad Roth.
Hi, I just had a, thank you very much. This is a very educational presentation. I was just wondering whether, I suppose that the questionnaire has the salutary effect of educating on these, on mediation, and whether you had thought about promulgating it more widely, not only for the purposes of conducting the research, but accomplishing the ends to which your research is going, or moving towards that.
Yeah, thank you, Brad. I'll go ahead and jump in here. That is certainly an interesting question and a different way of thinking about it. I do know as part of our research process, we always at the very end do offer a debriefing that is intended to educate people about what we're doing and the purpose of that. And we have links and things that go out that talk about these processes. as you were mentioning, sort of bringing this out to the world more broadly, I was thinking about different projects like Project Implicate, where they've created websites where people can go and do different surveys and things online. That's not something I had thought about before, but it's an interesting way of thinking about maybe moving forward on some of this work.
I imagine that if there was just standardly, if you were to go to a court or on a court website, that you had to fill out just this survey regarding your knowledge of these various dispute resolution options, whether or not that wouldn't have a, potentially quite a large effect of kind of getting the word out there, and almost should be standard practice, perhaps, in these different venues.
Yeah, that would be interesting. And it would also create an opportunity if we were interested in educational interventions. You could develop and test the effectiveness of those in those contexts. So that would be pretty cool.
We are at 10. So folks, I'm hoping the nods that I saw on some of my Hollywood squares meant that some of the speakers could stay, but we are at 10. Thank you very much everyone for joining. Number one, please join us next month. I'm afraid I don't have the information at my fingertips, but it'll be the first Thursday. And I don't remember the topic, but I remember that all the upcoming topics are very interesting. So we urge you to keep an eye out for that announcement. Number two, Mediation Settlement Day, which has been an annual event for, I don't know, maybe 20 years or something in New York, also celebrated outside of New York, is coming up. I think that date is October 21st. There was a link to it in the chat earlier on, and the theme for Mediation Settlement Day this year is mentorship, and the Frontline Champion Award is being given to Alexandra Carter, clinical professor at Columbia Law School.
Chuck, if I could add, our next breakfast is November 4th. The speaker will be Donna Hicks, the author of Dignity. Donna is at Harvard, and we look forward to seeing all of you on November 4th. And with that, we will thank you so much to the speakers. You've been absolutely terrific this morning, as you can see from all the wonderful reaction in the chat. With that, we will end the recording and continue chatting informally here.